Hey, friends and colleagues. It's me again, Chris Segers, professor of law, and your neighbor up to the north at CSU College of Law. Professor Altmaier asked me to film a short postscript to update the video on Federal Trade Commission versus Facebook and the general problem of antitrust in social media. And I'm happy to do that. And it turns out this just happens to be an opportune time to think about developments in the case because a lot has happened. I think the fairest thing to say about the FTC versus Facebook case itself is that it is at a moment of pregnant possibility. And let me say why. When I recorded that video in 2021, 3 years ago now, almost exactly 3 years, uh, something big had just happened, which was the government filed this big case, a long awaited case against Facebook, and one of the first really big cases by the federal government against the big tech monopolies, all of which had been promised for a long time, talked about, debated, but long delayed. Government filed that thing, but just before I recorded that video, in fact, just under 1 month before I recorded that video, there was sort of a blockbuster development, which was the trial court in the case, the federal district court for the District of Columbia, under the pen of Judge James Boasberg, dismissed the Federal Trade Commission's case, dismissed all the charges. But as I said at the very end of the last video, the court dismissed without prejudice as to some of the claims, meaning that they could be repled. And everyone, of course, assumed that the Federal Trade Commission would replead, and indeed it did. So the dismissal, that's usually not a very welcome sort of event, but it was one of those dismissals without prejudice that kind of lays out a roadmap for how to refile. And indeed, it wound up, it sort of gave the indication that the judge actually believed in the case, at least to some extent. And indeed, the Federal Trade Commission did refile, and about 6 months later, 6 months after the initial dismissal, Facebook again sought to dismiss the refiled First Amendment complaint, as defendants do. And this time, Judge Boasberg rejected the motion, denied the motion in its entirety, and the case was therefore allowed to proceed. Surviving dismissal definitely doesn't mean you're going to win. It just gets you to discovery, and that's where the parties have been for about the last 2 years. Well, the reason the case is now suddenly brimming with possibility, with potential, and eyes are going to be on it for a while, is that discovery is over. Discovery has concluded. The parties, I spent a little time prepping for this, looking through the docket, and they were in fairly difficult discovery disputes for a while. They've been taking each other's temperature for a couple of years and fought over a lot of stuff, as parties do. But that's all over. They have mutually sought the court's order to proceed, and so we are at the stage at which both parties may seek summary judgment. And that's going to be a big test for this case. If the evidence is such that the Federal Trade Commission can persuade Judge Boasberg that he was indeed wise to allow the case to proceed to discovery to see if the commission could support its claims, the time is nigh for him to make that call. So the state of play is that motion, a schedule has been set for motion practice. The final step in motion practice will be in about August. That's kind of a significant time of the year. If you follow my drift, this is an election year, and the folks in charge of the federal government may be changing in November of this year, only a month or two, a few months really, after the final filing is made in this case. So Judge Boasberg will have a summary judgment position fully briefed. I believe both parties will probably seek summary judgment on at least some issues, and Facebook will seek to terminate the case entirely through summary judgment, and Judge Boasberg will have to make that decision. If the Republican Party is to take the presidency. The Republican president will replace the leadership of the Federal Trade Commission, and it would not be the first time in history if the new leadership of the Federal Trade Commission were to seek dismissal of this case, to dispose of the case quickly. It has happened before that when parties, when the presidential party changes, and a big antitrust case had been pending right before the election, the new party, the new president will seek to dispose of a case that he or she doesn't approve of, and that seems pretty likely in this case. So if the presumptive nominee is Donald Trump, if President Trump wins the election, his new Federal Trade Commission, one imagines, would likely seek to settle the matter on some terms very favorable to Facebook. So this whole thing might go away before Judge Boasberg is even able to make his decision. But if the presumptive nominee for the Democratic Party is President Biden, and if he wins, this case will certainly go forward if Judge Boasberg allows it. So it will be very interesting to see what happens after November, and in particular after January, when the new president is sworn into office and can make appointments to the antitrust leadership. And it should be sometime around that period, early spring of 2025, that Judge Boasberg would rule on motions for summary judgment. So state of play right now, it's exciting stuff is going to happen over the summer. People are going to be debating this case quite a lot, and we will probably see some fireworks in this case in early 2025. Laying my own personal cards on the table, I think this is a solid case. I hope it goes forward. I believe in the government's case. To some extent, the government's case is weakened, as I said in the last video, only because the mergers, the acquisitions, at the heart of the case, Instagram and WhatsApp. When Facebook bought Instagram and WhatsApp, the government couldn't stop them. I mean, merger law is just so impotent these days, and in particular impotent to stop non-horizontal transactions like those were, that the government just couldn't do it. And by the time it was clear what the competitive threats were, it was 10 years later, and the government had to scramble to come up with a theory to challenge those acquisitions. And it's a good theory, but the problem is our law says you're supposed to bring your cases with reasonable promptness, and Judge Boasberg, to some large degree, granted dismissal because of some of the claims because the government brought them so late, and his remaining skepticism of even those claims that survive had something to do with his belief that the case had been delayed for so long, and there you have it. So I think it's a good case, and I'd like to see it go forward. I think liability. It's not actually that unlikely if the government decides to proceed. And I'll leave you with one last prediction about FTC versus Facebook. Even if Donald Trump is to win re-election, it's not impossible that this case will go forward. Remember, Donald Trump, when he was president previously, authorized and indeed appears to have strongly supported an antitrust challenge to a merger under his watch. That was a very significant merger challenge, a vertical merger challenge, the first vertical merger challenge in 40 years against the acquisition by AT&T of the Time Warner movie production outfit. Lost that case, but he nevertheless supported an aggressive, innovative antitrust enforcement. And here's the thing. Nobody knows why the president supported that case. Nobody knows why the case was brought, but it's been widely speculated that it had political motivations. Time Warner happened to include CNN, which is a generally left-leaning news outfit that had been quite critical of the president, and many people thought he supported antitrust enforcement because it was a way to punish a political rival. Well, that certainly might be true of Facebook as well. As we all know, there there's a strong sense in certain sectors of American society that the major social media platforms have discriminated against conservative viewpoints, and so he may very well support antitrust action against Facebook, just as kind of a gotcha. Who knows? One other thing I'll say before hanging up the phone here is there's a lot else going on in antitrust and big tech. You know, not strictly social media so much, but there are a number of other big government cases pending against big tech firms, and the resolution of those cases will definitely affect antitrust enforcement in big tech. So, as people probably know, for a long time there's been a pending Justice Department case against Google. The Justice Department case is thought to be pretty strong. It's a monopolization case. It's based on Google's exclusion of competitive search engines and so on, and focuses to some degree on Google's dominance in online ad revenues. That case proceeds and is thought to be quite strong. There is also a pending case by the Federal Trade Commission against Amazon. That is pending. And then, as people probably know, just earlier this month, the Justice Department dropped kind of a big bombshell. I mean, it wasn't unexpected, but the Justice Department finally sued Apple, and this is potentially the big daddy of them all. These are all big cases, but the Apple case is potentially the biggest for several reasons. I mean, for one thing, Apple is just big. As the government points out in this complaint, Apple earns operating profits, net profits, larger than the GDP of 100 countries. Apple earns revenues, income every year, in excess of the gross domestic products of 100 countries. 100 countries around the world generate less wealth every year than Apple rakes in through its very profitable businesses. The government also points out that Apple's businesses, and in particular its smartphone business and the mobile app distribution business, which are at the heart of this monopolization case, are extraordinarily profitable. Okay, so Apple's a big company, and taking on a big company makes it a big deal. Another thing that makes it a big deal is this case is very closely similar to the last really big blockbuster antitrust case, which was United States versus Microsoft. A very similar theory of harm underlies this case, and something very interesting that the government does not fail to point out is that the conduct that the government successfully prohibited in United States versus Microsoft 20 years ago had been a key stumbling block, a key barrier to Apple's growth as a business. Apple, we forget this now, but Apple was kind of a small, struggling business that narrowly avoided insolvency in the 1990s. And it was always, the sort of red-headed stepchild cousin, the tiny little pipsqueak upstart to the massive dominance of Microsoft back then. And the government points out in this case, and I believe it's true, stopping Microsoft's exclusionary anti-competitive conduct in that case in the late 1990s and early 2000s was key to Apple's, it's what made possible Apple's growth as a successful firm. And so the government points out a significant irony here. Apple was allowed to sort of exist as a firm because of antitrust enforcement against the same kind of conduct that is alleged in this case. So, the successful theory of harm in Microsoft is the same theory of harm here, and it was a celebrated case. And I wouldn't be surprised if the same theory works here. Again, though, we can't forget that antitrust to some large extent is politics. It always has been. And if a Republican administration takes office in November, the odds are pretty solid that all of these cases may go away. If they don't, or if they do, they all are important for antitrust and social media. The ability to enforce the antitrust laws against conduct that is important in social media sectors will be affected by the outcomes of all of these cases, even the ones that involve non-social media firms. And in particular, the effectiveness of remedies against firms that enjoy significant network externality benefits is an untested problem. It will be tested through experience with each of these cases. If the cases are allowed to proceed, and at least one or a few of them are successful, we will see whether remedies can really work in these markets that tend to favor dominance by large firms. Maybe we'll find out that that isn't such an inevitability, and antitrust remedies can have some beneficial effect. Remains to be seen. I hope it is seen. And there it is. Thanks, friends, for sticking with me. This has been a long road to hoe, and I'd just like to say one more time thank you to everyone for allowing me to do this. It's been a lot of fun. And I'll say one last time to Professor Altmaier, I'll see you on the field of battle.